Now, if you're faced with a difficult situation and family members are arguing about the right to dispose of a body, the question to be answered, who has the requisite authority? In the first instance, my advice is to look at the will and identify the executors. At face value, they should dispose of the body. You may also wish to check whether a grant of probate has issued, because not all executors named in the will are obliged to take out a grant. In that case, only the proving executors, i.e. those named on the grant, have authority. A simple check can be made on the Find a Will search online to establish whether a grant has been extracted. If there is a will, you need to consider the hierarchy and whether a grant of letters of administration have been taken out. If there is no grant, you need to documentation to confirm who you are receiving instructions from. A simple check. If it is a spouse, you can request a copy marriage certificate or birth certificates for children. I would also advocate obtaining ID, and don't forget the death certificate. You should keep copies to confirm the alleged authority. It's also common for various family members to deal with the burial or the cremation when a professional executor is administering the estate. They want to apply a personal touch. If that's the case, you might still want to speak to the PRs to confirm their written authority in order to confirm what's being proposed. Now, it is possible for disputes to arise between those entitled to deal with the body or ashes. For example, there may be two executors or siblings entitled to dispose of the body, and they may disagree as to the manner or place of disposal. An executor may wish for a burial, despite the will indicating the wish for a cremation. Alternatively, there could be a disagreement about where ashes should be disposed. No one has a casting vote, and as stated before, the will is not binding. It is not the place of a funeral director to mediate such issues. However, I am aware that in some circumstances you will be asked to provide an opinion, and I'm sure I don't need to tell you that it can be a dangerous path to tread. You could be accused of taking sides. If you feel comfortable brokering an agreement, then do so. A common sense approach is sometimes the best one. However, if no one will listen to reason, it may be that you say you can't act until an agreement is reached or the court has made a determination. You should take care in accepting instructions if there appears to be a disagreement. If no resolution can be found, it may be that a court has to intervene, but such applications are tricky. In resolving this, the courts are likely to adopt a practical approach. Dodd and Jones confirmed that it is often difficult to weigh up the competing claims and arrive at what one would truly call a legal judgment. Even if the deceased's wishes are known and may be of great influence, there may be religious factors or family tradition to take into account. A sensible course of action would be to advise that the family take independent legal advice. Now, I've spoken for a while now, and I apologise for the disruptions, but at this stage, are there any questions that people might want to put forward? I've seen a few things on
Thank you so much. That was excellent, Douglas. Maldwyn had a question. Maldwyn, are you able to type up that question again, please, about the conflict that you're having now? Sorry, back to you, Douglas, with James with a question about the information to do with Scottish law.
Okay, the answer to this one's quite short and sweet, really. The answer is no. Scottish burials and disputes, they're under a entirely separate jurisdiction. To be clear, that I'm providing purely relates to England and Wales, and indeed that's the area of law which I practice in. If you come across any issues in Scotland, you would be advised or best advised to speak to a Scottish lawyer. I've seen John's also asked about the hierarchy list. It's quite easy to get hold of, actually. If you just simply Google the non-contentious probate rules, or indeed look at section 46 of the Administration of Estates Act, the hierarchy is set out.
Douglas, can I come back to James's question about Scottish law? Does Elwyn Mitchell have a Scottish presence?
We do have a Glasgow-based office who deal with primarily property issues, but I do believe that we also have a private client team there as well. If an issue were to arise, it may be something that we could assist with. Okay. But I'm in a bit of difficulty to say much more, really, given my own expertise in the area in which I practice. So.
Cool. Do you want to move on to the next session? Madeline and any others want to type questions, we can pick them up at another juncture, yeah?
Okay, brilliant. Any questions as we go along, just please type them and we can always come back to them at the end, indeed. Okay, so I just thought I'd say a few words about fees as well, because in addition to the authority to deal with an estate, there's also the primary and very important question of who's going to pay your fees. Now, initially, this is a matter of contract with the person instructing you. They are primarily liable, but many people are unable to afford fees up front and will request that the fees come from the estate. Now, reasonable funeral costs are a testamentary expense which is deductible from the estate assets. This is set out in section 34 of the Administration of Estates Act 1925. Now, the question of reasonableness depends upon the deceased station in life and the manner in which they have lived. It's quite an archaic principle, but it still stands. If something is overly extravagant, you may wish to ensure that such matters are paid for in advance, or to seek the consent of the beneficiaries, otherwise there could be a dispute later on. In some circumstances, of course, a bank will allow funeral expenses to be paid directly from an account when no grant of probate has been extracted. You may therefore wish to seek evidence of liquid assets and to confirm the position with the bank beforehand. Further, you need to consider the position of what happens if the estate is insolvent. Only absolutely necessary expenses will be allowed as a testamentary expense in those circumstances, even if, had the estate been sold, the fees would have been considered reasonable. The personal representatives remain liable to pay such fees, and therefore you should take care if you're looking to wait for the fees to come out of the account. Now, I'd also just want to say a few words about two other types of claims, validity claims and 1975 Act claims for maintenance, which are the two of the most common claims which I come across. You may find yourself in a position where such claims are being discussed and a family member is unhappy with the terms of the will. Now, it's not possible for someone to simply challenge a will on the grounds of fairness. They have to have an identifiable cause of action. In order for a will to be valid, it must accord with the requirements of Section 9 of the Wills Act 1837. That is, it was signed in the presence of two witnesses who also attest to the testator's signature. The testator must have testamentary capacity at the time of the instructions and when the will was executed. And the testator must also have knowledge and approval of its terms and be free from any undue influence. Now, claims of this nature will usually involve a careful and detailed analysis of large amounts of factual data from the witnesses to the will, medical records, third-party witnesses, and the solicitor who was involved in the preparation of the will. Further, cases involving capacity will usually have expert evidence from GPs and geriatric psychiatrists. They can be long, drawn out, and take quite a long time to settle. Now, where such allegations are being pursued, it will normally hold up the administration of the estate. A claims is like a caveat, which is a mechanism which stops a grant of probate from being extracted and could potentially delay the payment of your fees. Further, where a claim is successfully pursued, the estate will normally fall to be administered upon the terms of the last will made prior to the disputed will, or if there is will, upon the rules of intestacy. This may have a significant bearing upon identifying the authority on which someone may be trying to make for the disposal of a body. If you are aware of a dispute of this nature, it might be sensible to check whether there could be a change of intention if different people were to administer the estate. It may have no bearing as the executors under one will may be the same as the executors under a previous will, or even if the people are different, they have the same view. But if the people are different, or a different view as to whether a burial should take place or a cremation, it would be sensible to try and bottom that out first. In certain circumstances, a court application can be made to obtain a limited grant of letters of administration purely in relation to the disposal of the body. Now, in addition, common claims under the Inheritance Provision for Family Independence Act 1975, otherwise commonly known as family provision claims, can also impact upon the administration of an estate. This provides the court with a framework to allow an adjustment to the terms of a will or intestacy to provide those in need of maintenance with financial support. Those who are eligible to apply are spouses and civil partners, cohabitees, former spouses who've not remarried, any person being maintained prior to death, and children, including adopted children, adult children, and those treated as children. Now, the concept of what is reasonable financial provision depends upon the category of the person claiming. The majority of applicants will only be allowed maintenance, that is, what is reasonably required to cover their day-to-day expenditure. However, spouses can receive whatever is reasonable in all the circumstances of the case, whether or not it is required for their maintenance. In considering an application under the 1975 Act, the court will ask itself two questions. One, does the will or intestacy provide the applicant with a reasonable financial provision for their maintenance? And if not, what would constitute such a provision? In considering such applications, the court will normally look at the whole host of factors at Section 3 of the Act, including the financial needs of the applicant, any other applicant or beneficiary in future or at the present time, any obligations and responsibilities of the deceased, the size and nature of the net estate, physical or mental disabilities, and any other relevant factor, including conduct. In essence, the court can take into account pretty much what it wants. There will also be additional factors specific to the type of claimant. For example, spouses are subject to what is known as the deemed divorce test. This is where the court will cross-check what an applicant would have received if they and the deceased had separated by divorce as opposed to death. Claims under the 1975 Act need to be issued promptly and within 6 months of the date of the grant of probate. This is a short time limit and clients need to act quickly. You can apply out of time if you have good reason, but only with the permission of the court. Now, this type of claim is unlikely to affect you. It doesn't impact upon the validity of the will and therefore the authority of those who have a right to dispose of the body. The net estate might be adjusted, but it does not change the status of funeral fees as a testamentary expense, and therefore the risk of you not being paid if there are estate assets is an absolute minimal one. Both types of claims are substantively not your concern, and you should be careful to engage and not show favour, or else it could cause problems. And the last thing you want to do is have any form of action which could impact upon your professional reputation. If it appears that such a dispute impacts on your position, my firm advice would be that you seek independent legal advice.
Douglas, thank you so much. We've got some questions in the chat box, and one of them from Maldwyn is a very hot topic, so if you could have a read of that and list your counsel, that would be great. Thank you.
Okay. If I understood the position correctly, well, it's not clear, first of all, whether the partner or those who paid for the ashes were also the personal representatives. If a grant of probate has been extracted or if there is a will, the decision should really be taken by the person who has firm authority to deal with the ashes. So if there is one executor, that executor has power to make the decision. If those who have paid are equally entitled to that decision, then, or if there's a conflict that can't be resolved by those who are equally entitled, then it could potentially require an application to court to try and work out who should actually deal with the ashes. The fact that they have paid is not itself the overriding factor. I would suggest, as a way of moving forward, that you speak to executors. Hopefully I've understood that correctly.
Okay, thank you. Malwyn may come back to you on a couple of points, but let's go to John Taylor. Well, has come back. There are no executors.
Are there no executors? I beg your pardon. Sorry, Terry. Was that in relation to Maldwyn's question?
Was, yes. And there are, so she's died intestate, no will.
Okay, then. Well, in that, if there were no executors, then I would look at Rule 22 of the non-contentious probate rules to consider the hierarchy. If, as I fear, there may be one or two people of the same ranking entitled to make that decision, then it may well be that an application to court is required if they cannot reasonably agree. In the interim, I'd decline to release the ashes until a firm decision had been made.
Mm-hmm. Okay. Great. Let's go on to the next question. John Taylor who is going, excuse me, about one of the points that you raised about reasonable and non-reasonable fees and for services requested. That was in relation to one of your earlier discussion points, I think, in who has authority.
Okay. In this context, it is a matter of degree depending upon the factual circumstances. And I would have thought 9 times out of 10, the majority of people would be able to figure out what is reasonable. But I appreciate that there will be situations when someone wants something much more elaborate than one might expect for an individual, given who they are and what they did during their life. If a family member is requesting something, then my argument would be that it's for the personal representatives to decide what is reasonable. Ultimately, they're responsible for the administration of the estate, and if they endorsed something that was overly extravagant or too costly, then the residuaries under the will might have cause for complaint. However, there's nothing to stop the residuary beneficiaries from consenting to something which might be a little bit more costly. So they ultimately could endorse what is reasonable. In the absence of their consent, however, I would be looking to the personal representatives to rule on that issue.
Sam has a good question about solicitors. They deal with waiting for grant of probate before their funeral director's fees are paid, but then some other solicitors will pay straight away. Do you have to wait for the grant of probate before paying funeral costs?
Well, my view is that it's back to the point of contract law at the start. The payment of your fees depends upon the term that you agreed with the person who is instructing you. So if you make clear to them at the time that you're engaged that you expect such fees to be paid within a particular period of time, then in theory you would be able to enforce that contract and seek payment of your fees straight away. The difficulty, however, arises when there is no available cash and someone might not have any money even if you were to go to court to enforce that contract. So, and I appreciate that some solicitors might be difficult to relate to the payment and wait until a grant of probate is a matter of course. There's no rule that says you have to wait for a grant of probate, but if that is the only way of releasing liquid assets, then it may be that has to be the appropriate course of action. I would argue that if there are cash assets in the estate, then and the bank will release them, there's no need to wait for a grant of probate. But in theory, there is also an argument that a grant of probate identifies formally and that confirms the payment of those reasonable charges. But plain devil's advocate, that also is a circular argument, because one might say, well, until the grant has been obtained, you can't deal with the funeral. Until that point, you don't fully know who has authority to deal with the body. I appreciate that's probably a bit of a lawyer's answer. I think you have to judge each particular fact on its own circumstances and consider whether it's appropriate to wait for a grant of probate or not.
Another question is, if there is a dispute within a family which they face, should we not say to the family, go and sort your problems out with a solicitor rather than with the funeral director? And as a lawyer, you know what you should say to that.
I think that's fair. If the family are being difficult and are trying to put you into an awkward position and effectively saying, what should we do? I think it's perfectly reasonable to say we're not here to mediate that dispute. We provide a service and we will provide that service to a high standard. But if you've got a dispute concerning the ashes or the burial, then that is for a lawyer, solicitor to resolve, and they should be directed to go and obtain independent legal advice. As I say, in some circumstances you may feel that you can offer a word of common sense, but at the same time you're under no obligation to do so. I
think Claire Maldwin would agree with you on that point. Any further questions from listeners? So we so appreciate your patience with us whilst we had technical glitches. What's going to happen at the end of this, there's going to be a feedback form. We're really grateful for, again, your patience. Douglas, thank you so much for sharing your advice. This session is recorded. It will be available. Douglas, can we use the PowerPoint slides and put it on the members' website? Is that okay?
Of course.
Great. Just also want to thank Angela, who's been really supportive sorting out this software glitches we've been having. So thank you all. Thank you, Douglas, for being with us. And good funeral directing. Take good care. Bye-bye.
Thank you. Bye.